What if you had the right to your opinions, but no right to act on them? You couldn't meet with your friends to talk things over or demand that your government do something about your concerns. The First Amendment protects not only your right to pure speech, but also your right to assemble with others to express your beliefs and to petition the government to solve the problem. What do you imagine when you think about protesting the government? Today, we often see groups demonstrating on streets, carrying signs to express their views. Yet for much of American history, such gatherings were forbidden by state and local governments because the First Amendment only applied to the federal government. However, in the early 1900s, the Supreme Court ruled that the First Amendment did apply to the states. It began to overturn local laws that banned demonstration on the sidewalks, which the court said were a public forum, places traditionally open to the public for meetings and discussions, such as parks, sidewalks, and streets. In such places, government could not forbid expression or regulate the content of the demonstration, but it could set limits on the time, place, and manner of the protests. For example, a city could prohibit marches in the public streets without a permit or forbid loud noises after a certain time in the evening. Of the two rights, assembly and petition, the second often takes a back seat today. But earlier in American history, when demonstrations were often illegal, the freedom to petition was a leading way people tried to influence their government. Thousands of people would join together to send signed petitions to Congress, showing broad support for change. In 1836, thousands of the Cherokee Nation signed a petition to Congress to protest their removal from their native lands, but Congress did it anyway. Before the Civil War, abolitionists sent thousands of petitions to Congress to abolish slavery, but Congress eventually refused to hear them. A new right that the Supreme Court has recognized under the First Amendment is freedom of association. In the late 1950s, during the Civil Rights Movement, Alabama tried to get membership lists from the National Association for the Advancement of Colored People. But the court ruled that to protect other First Amendment rights, freedom of association required confidentiality of memberships. Otherwise, the state could punish unpopular groups just by publishing a list of their members. How do you use the freedom of assembly, petition, and association today?